Starting with defamation in this no card reading, the four primary components of defamation is a defamatory statement about the claimant, which is published and which is likely to cause serious harm to the claimant's reputation. Two types of defamation include libel, which refers to permanent defamatory statements, such as what is written, broadcast, or otherwise performed. And I think published is maybe the word he's looking for. And slander. Slander is a defamatory statement which is not permanent. The key example is spoken word. Gestures can also constitute slander, since they are a form of non-permanent communication. The nature of defamatory communication. The words must tend to expose the plaintiff to distrust, hatred, contempt, ridicule, or bologai. It is not the hurtfulness of the words, but the effect of those words on a person's ability through reputation to engage in normal social intercourse. Meaning, one's, profession and one's upstanding in the community, and whether the meaning of a statement is libelous is not whether right thinking or the majority of people view the statement as libelous, but whether some people find it to be libelous, even if that group is the wrong thinking or minority group. And that comes from the Grant versus Reader's Digest Association case. And the one that came up with distrust, hatred, contempt, so exposing the plaintiff to distrust, hatred, contempt, ridicule, or bologai is Bell versus Orlando City newspaper. But back to Grant versus Reader's Digest Association, it is sufficient to show that the plaintiff's reputation would suffer before wrong-thinking people. Affirmative defense, the publication is true. In order to support a defendant of truth, it is necessary to prove merely that the statement was substantially true. Specific changes, however, cannot be proven as truth merely by showing the plaintiff's general bad character. So this is coming from the Killian versus Doubleday and Company case. What else do we have? To state a claim of liability, the plaintiff must plead that the statement refers to some ascertained or ascertainable person. And this comes from Neiman Marcus versus Lee. Statements about a class must have some particular circumstances which point to the plaintiff as a person defamed. And for a cause of action for libel, the plaintiff must show that a reasonable person who read the publication would identify it as a statement about the plaintiff. And that comes from Bindrum versus Mitchell, when a novel was written with basically the plaintiff as the main character, which wouldn't be readily obvious to everyone, but except for maybe the readers who happen to know about the plaintiff and his line of work. So, publication defined is the communication of the defamatory words to someone other than the person defamed. And this is Economopoulos versus A.G. Pollard Company, where somebody who works for A.G. Pollard Company told somebody who speaks Greek to tell the customer who is Greek that he thought that he saw him take something and to return it. And that publication was made out loud to another person, but the person couldn't hear it or couldn't understand it. Is a different language. So it must be understood also. And that's an element from this case, which is listing here as, in order for there to be a publication of a slanderous statement, the words must be spoken in the presence of others, and they must be understood. So again, publication can be speech, right? But it can also be, various other acts. It is defined as the communication of defamatory words to someone other than the person defamed. Remember, it is not the hurt caused to the plaintiff of the false accusation, but rather how others will view them. Without an understandable communication of the accusation to third parties, the plaintiff's reputation cannot suffer harm. Which is why it is in that fashion. Okay, so for the nature of a defamatory communication, the words must tend to expose the plaintiff to distrust, contempt, ridicule, or bulloquy. That's actually... Okay. I already read this, but I don't think I emphasized enough that... if the statement is true, that relieves the defendant from making the publication, or from any liability for making the publication. It is what is referred to as an affirmative defense. So for the defamation of public officials, which are the U.S. prohibits public officials from recovering damages for a defamatory falsehood relating to their official conduct unless they can prove the statement was with actual malice. Actual malice is when the speaker had knowledge that the statement was false or acts with a reckless regard to whether it is false or not. The standard of malice from St. Amant v. Thompson is, did the speaker in fact entertain serious doubts as to the truth of the publication? And this is more than just willful blindness. If you're a publisher and you seriously doubt that your publication is true and you don't invite or even take the time to read what's being supplied to you by the defendant's attorney or whomsoever, that would refute the truth, the publication that you're contemplating printing, then you probably will be found to be in reckless disregard to whether the publication is false or not. Publication with such doubts shows a reckless disregard for truth or falsity and demonstrates malice. The publisher cannot rely solely on his belief that the statement was true. The finder of fact must determine whether the publication was indeed made in good faith. In an action against a public figure, it is insufficient to establish an extreme departure from professional standards. Proof must be clear and convincing evidence of actual malice. This is in Hart Hanks Communication v. Connaughton. There's 2 bullets from that case. A failure to investigate will alone not support a finding of actual malice, but purposeful avoidance of the truth may. Like I demonstrated in my example. The court must exercise independent discretion to ensure compliance with the constitutional standard. For a private plaintiff versus a public official, A media source that publishes defamatory falsehoods about an individual who is neither a public official nor a public figure may be held to a lower standard than the New York Times versus Sullivan standard of actual malice. The states may define for themselves the appropriate standard of liability for a publisher of defamatory falsehoods injurious to a private individual. And this comes from Gertz versus Robert Welch, Inc. States may not permit recovery of presumed or punitive damages unless lies based on a showing of knowledge of falsity or reckless disregard for the truth. That is the New York Times standard. So, let's read this again further, set apart the difference between public officials and private plaintiffs. So for private plaintiffs, a media source that publishes defamatory falsehoods about an individual who is neither a public official nor a public figure may be held to a lower standard, may indeed be held to a lower standard than the publisher making defamatory statements about a public official, which means by lower standard means excusing the publisher excusing the plaintiff, the private plaintiff, from having to prove actual malice, whereas the public official must prove actual malice to recover for defamatory statements. States may define for themselves the appropriate standard of liability for a publisher of defamatory falsehoods injurious to a private individual. But, as you know already, it is the Constitution that requires, the Constitution that governs defamation of public officials. Now, this is because public officials is a public concern. So we want to protect free speech about public concerns such as public officials and their conduct. However, private plaintiff cannot recover damages without also showing that the statements at issue were false. And the burden is on the plaintiff to prove that they were false. And in such cases as like Philadelphia Inquirer versus Heck, where there's state statutes that disallow or do not require the publisher to admit to who their source is, that can be submit to jury. The election of that shield doctrine to protect the persons that come forward and provide information to the newspaper from the newspaper having to admit in a court of law who its source is. If that shield rule is exercised, the plaintiff is going to have trouble bearing the burden of showing that the statements that were made by the newspaper were false. However, in this case, Hepp versus Philadelphia Newspapers, Inc., aka the Philadelphia Inquirer, I would think that the court decided it was all right for the jury, for that evidence of the shield law being exercised to be submit to the jury, so that the jury in their decision on defamation and mainly on if the defamatory statement was incorrect will be considering the fact that the defendant isn't providing the source of its information. The privileges under defamation are absolute and conditional or qualified privileges. So, absolute is individuals in certain roles are protected from defamation claims. This takes two forms, the first being absolute privilege. This is enjoyed by parliamentarians as per the Bill of Rights of 1668, and members of the judiciary as per the Defamatory Act of 1996. So a qualified or conditional privilege to defamation is the second as a qualified privilege as per the Defamation Act, and covers situations in which an individual is obliged morally or statutorily to communicate information whilst an incorrect reference can be damaging. It will not give rise to a defamation claim here. The exception is if a reference is made maliciously. Now, publication of a defamatory statement may be constitutionally privileged when it is fairly made by a person in the discharge of public or private duty, whether legal or moral, or in the conduct of his own affairs in matters where his interest is concerned. See Sindorf versus Jackron Sales Company. And that's a private individual, right? That case involved Sindorf, I think. Yeah, Sindorf was formerly employed by Jackron Sales Company and left, but said that Jackron had owed him money, which is why he kept some of Jackron's property. And when Sindorf went to another company, Jackron, who knew the new employer, had a conversation with the new employer about mainly inquiring as to whether Sindorf had started working there when he was still working for Jackron, and also let him know to be careful about Sindorf having possession of some of the property of Jackron still. So any reasonable method of publication may be adopted which fits the purpose of protecting the particular interest. Sorry, let me read that interest one more time that we were discussing. The publication of defamatory statement may be constitutionally privileged when it is fairly made by a person in the discharge of some public or private duty. So that duty to inform the new employer of the misdeed, whether legal or moral duty, or in the conduct of his own affairs in matters where his interest is concerned, which is he wanted to know about his former employee. So any reasonable method of publication may be adopted which fits the purpose of protecting the particular interest. It is up to the defendant to prove that there was a proper interest or duty that justified publishing the statement. The privilege, however, can be lost if the statement is improper. To determine an abuse of privilege, all relevant circumstances are admissible. Falsity. Where a newspaper publishes speech of public concern or private figure, plaintiff cannot recover damages without also showing that the statement at issue are false, and the burden is on the plaintiff. But he doesn't have to prove malice. Okay, so that's it for the no cards from class. Now I think it would be a great time to continue on the same topic of defamation. Let's just thoroughly kill this thing. Defamation is an act of publishing an untrue statement which negatively affects someone's reputation. Taken at face value, this definition is obviously far-reaching. Luckily, both common and statute law has developed a framework to limit the extent of the tort of defamation. The key authority is the Defamation Act of 2013, not 1999 or 96, which helps straighten out the significant body of case law which has built up over the years. The overall aim of the act was to rebalance the law towards protecting freedom of speech. The same general definition of defamation still applies, but its elements have been slightly recast by the Act. The four primary components of defamation are: 1. A defamatory statement, 2. About the claimant, 3. Which is published, and 4. Which has caused or is likely to cause serious harm to the claimant's reputation. So I might add an unprivileged defamatory statement, which is false or in malice, sometimes an element, which is published and which has caused or is likely to cause serious harm to the claimant's reputation. So libel and slander are now being discussed. Libel and slander are simply two different types of defamation. Defamation is the overarching tort. Libel and slander are just two different ways of committing that tort. They both remain privy to the general principle governing the tort of defamation. Libel refers to the permanent defamatory statements, such as that which is written, broadcast, or otherwise performed. The permanence requirement doesn't mean forever, but rather communication which exists for longer than the time the original message is communicated. Thus, the courts have gone as far as suggesting that skywriting can constitute libel, such as writing takes time to disperse. Interesting. It didn't take too long to just write through this. This is kind of readable. Short notes on products liability. I'm going to make products liability a separate topic. In a moment, we're going to talk about defenses. But first, I think we'll talk about joint enterprise. The prime objective of the tort system is to compensate innocent victims harmed by faulty conduct. However, shifting the cost of these injuries onto the wrongdoers is arguably instrumental in achieving many other equally laudatory objectives. Forcing a manufacturer to bear the cost of injuries incurred from its products that are faulty in their nature or design may deter future misconduct and may tacitly encourage more careful behavior, such as increasingly diligent testing and product design. The cost of injuries from the use of a product may also then be built into the price of the product and passed on to the consumer. If these effects are realized, several goals that commonly fall into the rubric of enterprise liability may be accomplished. First, the cost of the risk will be borne by society generally of the innocent victim instead of the innocent alone. Second, the price of the product will reflect its true social cost. The price will then mediate consumer choice, resulting in optimum levels of production and purchase. As the price of the product increases as a result of internalizing the cost of injuries, the consumption of the product will decline as consumers switch to less costly alternatives, resulting ultimately in a decrease in injuries due to the use of the product. Thus, through enterprise liability, the tort system arguably insulates against overuse and overconsumption of relatively risky products. Moreover, enterprise liability may place the cost of injury avoidance on the least cost accident avoider. The manufacturer is often in the best position to accurately access the various ways of avoiding costs of injuries through redesign, quality control, and other safety measures. As a result of its level of access, the manufacturer is also often in the best position to insure against future injuries. Internalizing all of these costs, as well as the costs associated with injuries, into the price of the product may ultimately force the manufacturer to consider the true cost of certain products when making its choices of which products to produce. It is hoped that the end result of enterprise liability is a socially efficient output. Finally, placing the cost of the injury from the product onto the manufacturer that reaps the benefits from the sales of the product is morally the right and fair outcome under principles of distributive justice. That said nothing about joint enterprise, but thanks for trying. Self-defense. Existence of a privilege. Anyone is privileged to use reasonable force to defend himself against threatened battery on the part of another. Retaliation, which is a term of art, is true self-defense. Self-defense against threatened battery, not retaliation. When battery is no longer threatened, privilege terminates. Victim can then become a tortfeasor. So retaliation, I have no idea what they're trying to say with that. Okay. But it's a term of art. So, you can look it up in Black's Law Dictionary. When I feel like it. Reasonable belief. Victim reasonably believes that the force is necessary to protect himself against battery, even though there is in fact no necessity. A reasonable mistake will protect the actor against liability. Provocation. Insults, verbal threats, or opprobrious language justify the exercise of self-defense. Question. Answer. No. Ordinary care under the circumstances. Meaning that threats, right? Threats need to can be backed up a little bit. So even though threat is just plain old language, I mean, it could rise to the level of I don't know why it's under provocation, but it could provoke someone. Threats could provoke someone. I think they generally need to start coming about. Amount of force limited to the use of force that is or reasonably appears to be necessary for the protection against a threatened battery. B, reasonable under the circumstances. And C, what will determine reasonable: age, size, gender, relative strength, etc. 6, stand your ground versus retreat before using deadly force. And this differs in different jurisdictions. Injury to third party. If you are retaliating in defense of yourself and you harm someone else in doing so, I think you have a defense. Pretty. Okay, so notes for contributory negligence and assumption of risk. 4 legal effects of that behavior. Pure contributory negligence. Even 1% of fault of the plaintiff bars the plaintiff's case entirely and places the costs onto 2 people at fault. What does that mean? Undermines the goals of the tort. Okay, these are just statements about pure contributory negligence. And again, we've already read this. We already read about the clear the last clear chance rule. If the plaintiff can show that the negligent defendant had the last clear chance to avoid the accident, then plaintiff's contributory negligence will save the plaintiff from being barred from recovery. And pure comparative negligence theory from McIntyre case is that the jury will apportion the amount of liability to each one of the parties, and that can be 40-60, that can be 10-90, that can be 20-80. Pure modified comparative is a 51% rule that you see in McIntyre, that if plaintiff is more responsible for the accident than the defendant, then the case is barred. And equipoise is a 50-50 rule that bars a case if both parties are 50% at fault. Contributory negligence. I really wanted to see some on assumption of risk here, but we're reading about contributory negligence again. It only applies to negligence cases, right? So you're not going to use it as defense for an intentional tort. So you're not going to say, because the plaintiff was being a complete jerk, I administered a battery on his face, and try to blame him for being a complete jerk, because it doesn't work like that. Battery is an intentional tort, and you shouldn't be punching someone for the way they look. And anyway, contributory negligence in that sense is only a defense of a negligent act. So 2, then see if there is an affirmative defense to see if the defendant's liability is decreased because of contributory negligence by the plaintiff. This is some type of a procedural instruction right now. So anyway, examine the conduct of the plaintiff to see if all 5 elements of negligence have been met. And if so, look at what the legal impact of the contributory negligence is. There are 3 types: pure contributory negligence, modified comparative negligence, and pure comparative negligence. Since I just read the modified comparative negligence and pure comparative negligence, and pure contributory negligence, I also read. So we're done here. And last, we're going to just talk about products liability. In the introduction reading, this is an area of law where your role of counselor is as important or perhaps even more important than your role as advocate. Outside counsel, lawyers, engineers, and human factors experts work with responsible companies to try to assure that their designs and warnings will not result in the accidents that expose them to liability. This is about risk prevention. Product liability - negligence. A manufacturer of a product is liable for injuries even though there is no relationship between the manufacturer and the user. So we explain why that occurs, and basically what you're saying is there doesn't need to be a privity of contract. There's 2 types of warranties: express warranties and implied warranties. These are contract terms. I'm just going to try to get into that another time if I can. A strict liability and tort, which is a case in California, Greenman versus Yuba Power Products. Plaintiff brought a shopsmith for her husband, and he was later injured while using it because the screws that were holding the thing together didn't actually hold together. They were of poor quality. The screws came apart, and the piece of wood that he was sanding, flew out and hit him in the face. And the rule that was adopted by California was for strict liability for defective products due to its view that negligence and breach of warranty are not adequate causes of action to compensate the plaintiff in a cause of action based on harm caused by the product. Look at the facts here. What was wrong with the shopsmith? Why wasn't negligence law enough to provide plaintiffs with an adequate remedy? And under the restatement, section 402A, special liability of seller of product for physical harm to user or consumer, we have part 1 and part 2. If you remember, part 1 is one who sells any product with a defective condition reasonably dangerous to the user or consumer or to his property is subject to liability for physical harm thereby caused to the ultimate user or consumer or to his property. If A, the seller is engaged in the business of selling such a product, and B, it is expected to and does not reach the consumer or user without substantial change in the condition in which it is sold, and the rule stated in subsection 1 applies, although A, the seller has exercised all possible care in the preparation and sale of its product, and B, the user or consumer has not bought the product from or entered into any contractual relation with the seller. That is all I have to study right now. We'll come back and do some concept reviews and see if we can provide a couple more